This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today we're going to talk about how a truck versus a train usually ends up with the train winning and no one else winning. After a collision between an Amtrak train and a truck pulling a trailer, there were multiple lawsuits filed for injuries of people on the train and the widow of the truck driver. Bobby Jenkins, who died in the accident, was driving the truck when it was hit by the train. The collision occurred when, despite warning markers, Jenkins failed to stop at the point where the private road on which he was driving crossed the railroad track. In Progressive Paloverde Insurance versus BJ Trucking, a July 15, 2022 decision of the Fifth Circuit Court of Appeals established who was responsible for the accident, the resulting injuries, and where the insurance applied. On the day of the collision, Jenkins was hauling sand in southeastern Louisiana. He was driving a semi-truck pulling a dump trailer. But the truck and trailer were owned by BJ Trucking Earthmover, L.L.C, of which Jenkins was the only member. The 27 tons of sand he was hauling came from the Fluker Pit, which is on property leased from Fluker Farms, incorporated by Industrial Aggregates of the Florida Parishes. The private road on which Jenkins was driving was allegedly owned by Kent Enterprises, L.L.C. Jenkins attempted to cross the railroad track at the DOT number 930094V. The crossing there is marked by 2 stop signs and 2 crossbucks. Illinois Central Railroad owns the track on which the Amtrak train was traveling at the time. The train was traveling at the permitted track speed of 79 miles an hour. Jenkins neither slowed nor stopped at the crossing as he approached it. Video surveillance recorded by the train established that while approaching the crossing, Bobby Jenkins ignored the stop sign and the crossbucks and did not slow down. Jenkins drove into the crossing, and he and the vehicle were struck by the train. Jenkins' widow, Katie Jenkins, filed the original lawsuit in state court, and a series of related cases were then consolidated between multiple parties. Progressive Paloverde Insurance Company insured the truck that Jenkins was driving. Heck Industries was alleged to have been Jenkins' employer at the time of the accident, but Heck insisted that Jenkins was working as an independent contractor. Heck submitted a defense and indemnity claim to Progressive because Heck was named as an additional insured on the Jenkins policy. Gray Insurance Company insured Heck but maintains its policy provided only excess coverage for Heck. Gray contends that the Progressive policy should be primary. Progressive filed a declaratory judgment complaint to determine whether it owed defense or indemnity to any of the named defendants. In a series of orders granting summary judgment, the district court concluded: 1. The sole cause of the collision between the truck driven by Bobby Jenkins and operated by Bobby Jenkins and BJ Trucking was the negligence of Bobby Jenkins. 2. Heck was not an employer of Bobby Jenkins or BJ Trucking. 3. Progressive's non-trucking insurance policy did not cover the 1998 Peterbilt truck driven by Bobby Jenkins at the time of the collision. And 4. Industrial Aggregates breached no duty to maintain the railroad crossing. On appeal, the issues were framed as follows. 1. Did the district court err in granting summary judgment holding that Jenkins was the sole cause of the collision? 2. Did the district court err in holding that Jenkins was not an employee of Heck? And 3. Did the district court err in holding that Progressive's non-trucking exclusion barred its policy coverage for this accident? Injured people employed on the train brought their claims under the Federal Employers' Liability Act, FELA. FELA provides an exclusive remedy for a railroad employee engaged in interstate commerce whose injury resulted from the negligence of the railroad. Awarding summary judgment to the defendant railroad is only appropriate when there is a complete absence of probative facts to support a jury verdict in the plaintiff's favor. Under Louisiana law, a motorist approaching a railroad crossing marked by a stop sign must stop and may not proceed until he can do so safely. When the crossing is marked by a crossbuck, such a motorist must also listen and look in both directions along such track for any approaching train and for signals indicating the approach of a train. He must yield the right of way to any approaching train and then shall proceed only upon exercising due care and upon being sure that it is safe to proceed. A motorist's failure to comply with these duties suffers legal consequences. There was no evidence of defect in the crossing. Amtrak met the burden by providing a crossing that can be traversed by a motorist who uses reasonable care. That is especially true in this case because Jenkins was familiar with the crossing. He had crossed it on a near daily basis over several years. Now, was he an employee or an independent contractor? Employers are responsible for the damage caused by their employees, but a principal cannot be held liable for the acts of an independent contractor. Jenkins was not Heck's employee. Heck, therefore, was not responsible for Jenkins' actions. The question whether an actor is an employee or an independent contractor may be resolved as a matter of law when the facts are not in dispute. The element of control that distinguishes an employee from an independent contractor focuses on whether the purported employer had the right to control the method and means by which the individual performed the work tasks. It matters less what supervision and control is actually exercised. The important question is whether from the nature of the relationship the right to do so exists. Heck, from the evidence presented, did not have any control over the manner in which Jenkins completed his work. Heck based payment to Jenkins on each discrete load. Jenkins controlled his own schedule, and either he or Heck could have terminated the relationship at any point. The district court was correct that Heck did not exercise and did not have the ability to exercise control over the manner and means in which Jenkins completed his work. On the insurance issue, Jenkins' policy with Progressive named Heck as an additional insured. Heck pleaded that Progressive was obligated to defend, indemnify, and insure Heck for the accident. However, the district court agreed with Progressive that its non-trucking exclusion, specifically ordered by Jenkins, barred coverage of Heck. At the time of the accident, Jenkins was hauling 27 tons of sand. The non-trucking exclusion applied because Jenkins was indisputably hauling property at the point of the collision. The district court was correct in holding that Progressive's policy did not cover Jenkins' truck or its trailer during the accident because those vehicles were unquestionably hauling property, and that function was clearly excluded from coverage. No party in the appeal had standing to challenge the dismissals of Industrial Aggregates or Gray, and their dismissals therefore stood. Similarly, Kent was properly dismissed from this appeal by a joint motion. The trial court simply did not err, and its judgment was affirmed. Mr. Jenkins limited the insurance coverage he bought to protect third parties he might injure while operating his tractor. and acquired a policy that excluded coverage while he was hauling property. He was clearly negligent, and that negligence caused his death as well as injury to those on the train and the train itself. No coverage for anyone, and the finding that he was solely responsible for the accident and injuries. The injuries could only collect then from his estate. It was sad for those injured who would not have been injured had he stopped at the crossing, but the law is clear and the ruling will stand. This video was adapted from my blog, Zalma on Insurance, which is available at www.zalma.com/blog. If you found this video to be useful or interesting, you might want to subscribe to the blog so that you can read the daily presentations, and let your friends and colleagues know. Thank you for your attention.